Hi folks, Alex Woods here, civil litigator with Redwood Legal. Now I haven't done a vlog on contested wills, probate and Inheritance Act matters for a while, so I thought I'd do one. I've actually had a couple of cases come in recently where we've had to give some advice to the client. I'm going to look at the facts of one particular case because I think it's a very good case study of the problems facing children if they are planning to bring a claim against their parents' estate after death and they have been cut out of the will. So this is actually a vlog aimed at parents who actually want to cut their children out of the will, and the big question is, in UK law, the courts of England and Wales, is whether they can do that. Is it actually possible for a parent to cut their child out of the will? Now, obviously there are moral issues around that, and I'll just touch on those at the end of the vlog. But, you know, leaving moral issues aside, I'm a lawyer. My job is to advise my clients on the legal position. So that is what I'm going to do, and I'm going to try and answer that question. For those, let's say you are a child watching this vlog, I have done other videos, specifically the Inheritance Act vlog, and I will link that in the description box below, on the circumstances where a will can be challenged, where a child has been cut out of the will. But I'm not going to deal with that in this vlog today. This vlog is aimed at parents who, for whatever reason, and let's be fair about it, there may be very good reason for a parent to want to leave children out of their will. It's aimed at you and whether or not you successfully do that. Okay, so I will touch on the facts of this particular case, where we have in fact had to tell the client, a daughter of the deceased, that unfortunately there's simply no point in even attempting to challenge the will through the courts. And this is quite a sad tale in many ways, because my client is a 50-year-old lady. She is, you know, very close to the poverty line. She lives in accommodation, really quite a small property, a terraced house in London, and she is on benefits. And in fact, she even had an accident a few years ago such that she is unable to work, and she has a son that she's having to bring up, and her surviving mother, who separated from the deceased many years back, is also not particularly well heeled. And it really did look on the face of it as if this was a sort of perfect territory, if you like, for making what's called an Inheritance Act claim against the estate of a parent. Yeah, but unfortunately, the deceased had probably taken advice from lawyers and had carefully planned, and I think also his partner. He wasn't married, but after he divorced our client's mother, he then hitched up with another woman in quite sort of what's clandestine circumstances. There was another woman that forced my client's mother out of the family home. So as you can see, so quite a sort of a sorry Dickensian situation. But he made a proper provision before he died, and actually a long way before he died, in order to make sure, regrettably, that his only daughter didn't receive any of the estate. I mean, to sort of, you know, fully paint the picture, this was a situation where the partner of the deceased actually, you know, didn't tell my client about the fact that her father was at death's door. Father and daughter were estranged because of, you know, the fact that he'd hitched up with another woman. And she turned up at the funeral to be presented with a copy of the will and a letter of wishes, and sort of something of a fait accompli by her smarter, better heeled and legally informed opponent, the surviving partner in this case, the lady who ended up inheriting everything. And in fact, it gets worse. As is so often the case in contested will matters, the estate was a property that was owned pretty much outright, and the partner of the deceased had actually got her own property as well, which I think she owned pretty much outright too. So it wasn't as if, the surviving partner of the deceased was in financial difficulties herself, such that the court might factor that into any equation if an Inheritance Act claim would have been brought by our client, by us, against her. So there it is, on the face of it, a very strong moral force to our client wanting to seek legal redress through the courts of England and Wales in order to at least get something out of the estate in order to provide for her financial needs and the financial needs of her son, who actually had a disability himself. So I actually went and visited these clients, and I was touched by the situation, and I actually didn't feel that my client was, a money grabber whatsoever. And she just felt that what had happened was wrong, and I actually thought that there might well be a reasonable case to proceed in the courts against the surviving partner, the other woman. Yeah. Now, I should just say that there is a landmark case in this area of law now called Eilert and Mitson, and it went all the way to the Supreme Court, and it was the classic case, I'll link it in the description box below, of a mother leaving everything to the Battersea Dogs Home. In fact, I think she did leave everything to animal charities, and leaving absolutely nothing to her estranged daughter, who, just as in this case, was in financial difficulties. Now, I'm not going to talk about that case here, but I will talk about that in another vlog. But it has set the tone, it set the sort of the legal landscape in cases of this sort. Anyway, to deal with this issue of whether you can actually take steps in order to prevent your child inheriting, what happened in this case is that the parent actually made plans a long way before their death, and what they did is, and I'm talking 15 years ago, actually transferred that property into the joint name of the other woman. So if you go onto the land registry, and this is something that's absolute first step you really need to take if you are in this situation, is to, invariably bigger part of an estate is probably going to be a property. Go to the land registry and find out what the legal status of the ownership of that property is, because if the property is in joint names, if it is what's called in English law a joint tenancy, and not tenants in common, and not some other form like it's a declaration of trust or something of that nature, if it's simply a joint tenancy, then the rules of survivorship are that upon death of one of the two people who is a joint tenant, upon death, the dead person's share goes to the survivor. Bam. And that is it. Period. End of story. So actually, in this case, there was no estate that my client could go after, because it was not owned by the deceased. The rules of a joint tenancy are that automatically the deceased share goes to the survivor. So basically, this particular plane couldn't even get off the runway, okay? And to conclude, if you are wanting to make sure that your children don't inherit, what you have to do is plan ahead, okay? Because what's interesting is, under the Inheritance Act, which is sort of the main weapon a child would have against an estate, the Inheritance Act can actually look back 6 years before death, and if property has been transferred within that period, it could fall into the estate. Yeah. So, providing that you do it well in advance, of course, few people do make proper provision well in advance. They often make wills a lot closer to death than 6 years, but if you do it well in advance, if you do basically transfer your properties into joint ownership with somebody else, that property automatically goes to them upon their death, and that is simply the end of the story. The door is closed. In Ireland and Mitson, that wasn't the situation because there was an estate to go after, yeah? So don't confuse, and as I say, I'll address this in another vlog and also look at the vlog that I've linked below. In Ireland and Mitson, there was an estate, there was a pot of money. The issue for the court was whether or not they felt that the daughter had a claim under the Inheritance Act. And it's also worth noting that the issue was actually how much. The daughter did actually get some money ultimately. She got $50,000 or something of that order, but she didn't get the 200 or 250,000 that she was claiming. The Supreme Court wouldn't let her have that, and I dare say, I'm not sure how costs were dealt with in that case, but I dare say it was a bit of a hollow victory for the daughter in that instance. So there it is, just to conclude and be clear about that. You don't want your children to be able to make a claim against your estate after you die. What do you do? Well before your death, and certainly it has to be more than 6 years before your death, you basically transfer any sole ownership you have in property into the joint ownership, and you become joint tenants with somebody else, whether it's your partner or perhaps another child, or indeed it could be anything, and then you are protected from claim under the Inheritance Act or any other claim against the estate after your death. And I did say I would touch on the moral issue around this, and I actually would advise a parent to at least leave a little bit of money in the will to a child. I think actually, in order to sort of make this sort of a copper bottom type arrangement, if you are a parent and determined to exclude a child from the will, then it is wise and prudent to just leave something. And why do I say that? Well, because if you've left something, you then basically close the door to, or at least, if not close it, well, let's say you close the door rather than bolt it and lock it. But you make it a lot more difficult for a child to challenge the will under the Inheritance Act claim, because one of the criteria of challenging a will is, that proper financial provision has not been made for a child. And the law changes. I mean, a decade ago, the courts took a different view and started to get involved morally in the issues of children being cut out of the will. But as I say, the current state of the law in Ireland and Mitson Supreme Court it reaffirms an age-old principle that someone is allowed to do what they want with their money when they die. But as I say, that's the Inheritance Act 1975 cuts across that. So in order to close the door to potential Inheritance Act claim, I would always advise a parent to think just very carefully about really being quite so comprehensive and actually don't leave them without anything at all, but make some, even if it's some small provision for that child, because that will actually help you, because who knows, in 10, 15, 20 years time when you die, maybe the law will have changed again, and you might get a judge who's a bit friendly to the child. That will help you to address that issue and make that will copper bottomed. Just to be clear, there are very many ways of challenging a will or challenging the estate. If someone dies without making a will, they die intestate. But I'm just talking about a situation where there is a valid will and there's no issue of mental incapacity or undue influence or lack of approval and sort of promissory estoppel and so on and so forth. I'm talking about the simple, clean situation where there is a will and the will is accepted as being valid by the courts. So if you are a child and you are interested in exploring avenues to bringing a claim against your parents' estate after death, that's not impossible. The point that I'm making today is that a parent can actually plan ahead and transfer ownership in properties into the joint ownership of somebody else, so that you are prevented from even getting a claim off of the ground. Thank you for tuning in. If you are interested in getting some advice from us, the way that we work, and I'm finding this is quite a successful way of running things, and it's the way we ran things in the case that I mentioned, and the way I've been running 2 recent contested will cases that have landed on my desk. And that is basically email us all the relevant documents. We'll liaise with the litigation assistant here, and they'll help you upload documents to the firm's sort of own cloud Dropbox system. And we will then review the documents, have a phone call with you, and basically tell you, whether you can get this particular plane off of the ground or whether you're wasting your time. And I'm not going to be pinned down to a fixed figure, but I will say that in the last 2 or 3 cases we've charged the client about 500, maximum 750, that sort of figure, plus VAT, in order to complete that preliminary review. It's really important that you complete that preliminary review, because preparation and doing proper investigations is really critical. Knowing what the size of the estate is, and we need to get a good idea of the whether you've got an arguable case against the estate. So it's actually not very much money when you consider the size, potential size of the estate. And in the cases that I've alluded to, we're talking about, a quarter or a half of £1 million. So that's the way we operate, and you can email us at info@redwoodlegal.co.uk. Finally, please do subscribe to the channel. Click subscribe. It helps to boost our profile on those good old YouTube and Google rankings. As I say, I will be doing another vlog shortly from the perspective of a child, just to look at circumstances where it is possible for a child to make a claim against the estate. But one area in which it's not possible for a claim to be made against an estate is where there is no estate for a claim to be made against. And in the case that I've alluded to, not just a property, also there was a bank account with 20 odd grand in it, and a claim couldn't even be made against that, because likewise many years ago the deceased had put the bank account into the joint names of himself and his partner. So be warned.